As mentioned, the motion is that RUU 355 should be made into law.
Ladies and gentlemen, there are too many misconceptions and there are too many confusions regarding RUU 355 that was proposed by Datuk Haji Adi Awang. So here tonight, I hope to discuss two things in relation to RUU 355, what it is and what it is not. First, ladies and gentlemen, RUU 355 is a very short law to amend an existing law. It has only effectively two main sections to amend laws which has existed about 33 years ago, which is in 1984. What does it do? What does it seek to do? It seeks to increase the limits of sentencing of existing offences. So what it does is actually it increases the limit from 3 years to 30 years, 5,000 ringgit to 100,000 ringgit, 6 strokes to 100 strokes in accordance with Sharia principle. Now this is not new. It has been done before in 84, where it was increased from 6 months to 3 years, 1,000 to 5,000 fine, and introduced the punishment of whipping. So that was in 1965. So it is a law, ladies and gentlemen, to increase the sentencing limit of existing offences, to amend laws which have existed for 33 years, since 1984. That is what RUU 355 is about, nothing more. Now, RUU 355, ladies and gentlemen, is expressly mandated by our Constitution. Now, List 2 of the 9th schedule states the state's power to legislate. Now, the state has power to legislate on Sharia offences to be tried in Sharia court. And what are the limits of the Sharia offences? It is expressly stated in the 9th schedule. What does it say? The Sharia court shall not have jurisdiction in respect of offences. So it does not have any jurisdiction. That is how it is worded. Except in so far as it is conferred by federal law. So what does it say? It says that Sharia courts limits are set by the federal law. And so what is the federal law that we're referring to? It is Act 355 and its preceding act. So it is actually expressly mandated by our Constitution. And since it is expressly mandated, it cannot be said to be unconstitutional, because it is provided for expressly in the Constitution. So, number 2, RUU 355 is mandated expressly by the Federal Constitution. Number 3, RUU 355 is not a substantive law. Its function is only to increase, as I mentioned just now, the sentencing limits, and it does not introduce any new offences. It is more of a procedural law as opposed to a substantive law. It does not impose any offences on persons committing a crime. So where is this substantive law? This substantive law are the state enactments that we have had for 60, 70 years and even predating our Constitution. Now, each of these substantive laws, ladies and gentlemen, are not done at whims and fancies. It must go through our state legislature. It has to be passed through democratic process. And that is how the state enactments in relation to Sharia are enacted. So if any state legislature passes a law beyond such prescribed limit, such law would be unconstitutional. So this is what happened in Kelantan. Certain provisions exceeds the law prescribed by the federal law. And therefore, those provisions cannot be enforced. And it has not been enforced. So, And it is also important to note our Act 355 and its preceding act has never been judged by the courts as unconstitutional. So I repeat again, it is not a substantive law, but merely a procedural law. Okay, what does it mean? I will explain further. The other thing that has caused so much misconceptions is in relation to non-Muslims. It is not applicable to non-Muslims. RUU is about increasing sentences of Sharia offences. No non-Muslims has ever been tried or can be tried in the Sharia court. Why? Because there is a constitutional safeguard for that. Item 1 of list 2 of the 9th schedule again states, the Sharia courts shall have jurisdictions only over persons professing religion of Islam. That is why, ladies and gentlemen, if you look for the past 60 years, how many non-Muslims do you know have been convicted or persecuted for offenses for not fasting during Ramadan? None. How many non-Muslims have been convicted for not going to Friday prayers? None. None whatsoever. And it will not be persecuted. It will not be applied in the future as well. So, ladies and gentlemen, RUU 355 cannot apply to non-Muslims. It and its predecessor has never been applied and will never be applied to non-Muslims because of these constitutional safeguards. Now, the other major misconceptions, is that it is about hudud. RUU 355 is not hudud. There is no mention of hudud. As mentioned above, it only increases the sentencing limit of existing permitted Sharia criminal offences which are to be tried under the Sharia court. And what are the existing offences? I think many are not aware. Now, for hudud, there are about 6 to 7 offences. Right? Now, for those who do not know, we have had these hudud type offences predating for decades and decades, even predating our constitution. These offences have been there for a long time, and it has been applied to all Muslims. Right? Now, if a case in point is the hudud type, for the hudud type offences, you can find it in the Selangor Administration of Muslim Law Enactment 1952. And it's before 1957. And if you trace back some of the hudud offences, you can trace back to Kanun Jenayah Melaka since 1500. So for the Muslims, it has been applied to them. These hudud type offences has been applied to them for a very long time. Right? Now, what is the difference now is that the sentences are being increased. But this is not new again. It has been done before. In 84, they increased the limits of sentences of 1965. Right? So, what is the difference? It's only in relation to the increasing of the sentences. Right? For me, I think it is a fair argument if someone wants to argue what the limits should be for the RUU 355. To argue about it's about introducing hudud, it's not tenable. To argue what should be the limit, it's very subjective, but it is a fair argument to me. But in order to argue, we also need to see how it is done under the civil law. So, what is hudud and other Sharia offences are about personal matters. Regulation of personal matters, reflecting the social value of the Muslims. Now, if we look at the penal offences, there are a number of offences in relation to social value as well, in relation to how we conduct ourselves. right? And if you look some of the offences that we have right now, okay, 5 minutes, okay, that we have right now, you would see the offences are up to 20 to 30 years, with also a penalty of whipping. You can check, see sections 376 onwards under the penal code. So we can argue in relation to what should be limit, but to argue that it is in relating to hudud, I think that is not correct, because hudud has existed for many, many years and many, many decades. The other thing to note about this hudud is that it doesn't apply to the 3 hudud offences that I've mentioned just now, which has not been in our country. Those type of hududs, for example, are sarikat, which is actually theft, which everybody I think would have read, leads to amputation of hand. Why is it not under any of our Sharia enactments? If it is, it will be unconstitutional. You know why? Because our constitution does not permit it. So let me relate to, again, the 9th schedule. Now, the state legislature has power to legislate on punishment of offences by person professing the religion of Islam against the precept of that religion, except in regards of 2 matters included in the federal list. So this is what has happened. There is no Sharia enactment in relation to theft which it can be enforced, because theft is part of the penal code, which is part of the federal list, right? If there are any provisions which touch the penal code, which is offences under the penal code, that would touch on the federal matters and therefore would be unconstitutional. That is why this RUU 355, to say that it introduced new hudud, it cannot be, because we have again a constitutional restriction. And to argue that it is about hudud, it cannot be as well, because it has been there for decades and decades, right? The only issue, if you want to argue, is what should be the limit. But this is, as mentioned just now, it's a subjective matter, but we can argue on that. So, if I may relate, that is why to a number of Muslims, to many Muslims, they cannot see why this should be objected. They have lived with this Muslim type of hudud offences for a number of years. And this sentencing is not only about hudud, it's also about non-hudud type of offences, which are many more than the hudud offences, which are about 3 or 4, right? Now, going forward, right, why probably some of the reason that probably we need to increase, probably to have a higher sentences in relation to propagation of ISIS doctrine. Now it is very limited, so this can be increased. So who decides this? It's the state legislature. Allow the state legislature to decide. Each state has their own legislature, elected by the people themselves. They decide what should be the value to be imposed in each state. So because of that, ladies and gentlemen, it is my view that RUU, to say RUU 355 is about hudud, is not tenable. It is wrong, and it is actually a false scaremongering allegation. I believe my time will be running out soon, so let me conclude the position. 1, as I mentioned just now, RUU is a short law to amend the sentencing limits, which has existed for 33 years. It is expressly mandated by the Constitution and therefore cannot be said to be unconstitutional. 20 seconds. It is not a substantive law creating offences. The substantive laws are the various state Sharia laws which must be democratically passed by the legislature. It cannot apply to non-Muslim. No non-Muslim has ever been persecuted by Sharia courts and will never be, as there is a constitutional safeguard. And finally, it cannot be introducing hudud, Anyone arguing as such is making a false scaremongering allegation. Hudud type offences have been with us since even before Merdeka. No new hudud offences can be introduced. With that, ladies and gentlemen, I end my discourse. Thank you.
Of the constitutionality of RUU 355. I'm aware that there are two schools of thought on this issue. But let me start my discussion by looking at the proviso that is being amended by Tuan Haji. And what it does is, it basically, it changes the 3 years, it increases it now to 30 years, so that's 10 times. It changes the 5,000, amends the 5,000 limit, makes it 100,000, which is 20 times what it was. And then it amends the 6 strokes to 100 lashes, which is 16 times about what it was. The key here, though, is not so much the punishment for me, but in fact the words that just precede that. You have to read the proviso as a whole. And these are the key words. It says, provided that such jurisdiction shall not be exercised in respect of any offense punishable with, and then they talk about the punishment. So it says the jurisdiction of the Sharia court shall not be exercised in respect of any offense. The offenses are not named in this amendment, all right? Any offense punishable with imprisonment. So in other words, the offense is defined by the punishment, not the other way around. Normally, it should be the punishment that is defined by the offense. Here, it is the offense that defines the punishment. So what we have here then, we have to now scour around all the state legislation and see what could possibly fall within the scope of that punishment. And then we can derive from that, perhaps, what offenses are covered. Now, if we are guided by the Kelantan enactment, by the way, which actually defines hudud, it sets out the hudud offenses. So if we look at zina liwat, okay, where the offender is Gairu Mohsan, all right, not previously had sexual relations, it's 100 lashes and imprisonment for a year. So that falls within the scope of the amendment. Khazaf, 80 lashes. Hazaf is false accusation of adultery or sodomy. That falls within that scope. Shurb, which is maximum of 80 lashes now. I'm talking about the present one in view of the amendment. And not less than 40 lashes. That is consuming alcohol. So those are 3 examples. But that comes out of the list of hudud offenses as defined by the Kelantan enactment. So as far as I'm concerned, I agree. It doesn't include the offenses where the punishment is stoning or death, but it does include the other hudud offenses. So in my submission, as I would say in court, in my view, this does cover hudud offenses. Hudud is covered by this amendment. It wouldn't have been covered before. It is covered now. So for that reason, I would argue that it goes against the basic structure of our federal constitution and is therefore unconstitutional. Now, Schedule 9 does not allow Sharia courts jurisdiction over criminal matters and matters in the federal list, for example, which includes intoxicating liquors and sexual offenses, cannot be covered by this law. Now, so the argument of my learned friend that once the federal law empowers Sharia courts, then they can go ahead and operate accordingly. But the federal law must also conform to the Constitution. It cannot run away from the federal list. It cannot empower the Sharia court to do something that is within the federal list. So that is the limitation. You can't run away from that limitation. Now, even if it is found to be constitutional, and a court of law will have to do that, there are other issues that I believe should be considered. One is, there are absolutely no reasons given apart from empowering the Sharia court. That's the reason given, making it stronger, empowering it. No other reasons are given as to why you need to increase these sentences to the extent that it's being increased. So, for example, in the earlier days, when they introduced the death penalty for drugs, they had to provide Parliament with a solid basis for doing that. It was because drugs were a menace. And there were reasons why, at that time, I don't agree with it at all, I don't agree with the death sentence, that was passed. So if you're going to increase sentences in the way that you propose to do, you have to explain to Parliament what is the problem you are trying to address in wanting to increase those sentences. So the rationale, as I said, was memperkasakan Mahkamah Syariah. They wanted to strengthen Mahkamah Syariah. We're all for that. Nothing wrong with that. My question is, how does this achieve it? And I would submit it doesn't. How do you empower the courts? How do you strengthen the courts? Not just Sharia, even our courts, civil courts. You improve infrastructure. You invest in training and upgrading. You remove systemic weaknesses. Sisters in Islam has said, given this figure, they say that the implementation of family law is what is required. For example, statistics show in 2015, the second highest number of cases involved unpaid child maintenance, while the highest was child custody. That has to be addressed. That's one way you can strengthen the Sharia courts. That's how you strengthen the infrastructure of the courts. That's how you strengthen the courts. How does this legislation strengthen the Sharia courts? I don't quite see how it does. Then I move on to the next point, proportionality. The question of proportionality is a simple rule. The punishment must fit the crime. Is it proportionate to allow up to 100 lashes for shurb, for example, or 80 for qazaf, false accusation? What about the 30-year punishment? Is it reasonable? Our penal code, we have 30 years for homicide, I believe, culpable homicide not amounting to murder. Can you compare the two? And there are others, robbery and so on. Those kinds of offenses carry those number of years of punishment. Can you compare that with consumption of alcohol and the others? So there must be some parity of reasoning, parity between the offenses that are being punished. Generally, and also, of course, the Sabah and Sarawak have been told, I'm not sure if this is accurate, that they don't necessarily have to adopt the position in RUU 355. I'm not sure if that's correct, actually. So you could have states who may not adopt RUU 355. So what happens there? Each state will then have differing punishments. So again, is that something that is good? That is something we should encourage. Now, principles in criminal legislation, all right, where there are penal consequences. This is what I'm going to ask the MPs who are voting on this bill to please have in mind. There are guidelines to how you enact criminal legislation. First, the offense must be clearly defined. And I ask you to test 355 against these principles. The offense must be clearly defined. RUU does not define any offense. Number two, there must be legal certainty as to the punishment. So in other words, you can't say up to 100 lashes. It has to be a reasonable number, and then you give the adjudicator a discretion. Number three, there must be parity in punishment. For example, similar sentences for similar offenses. You can't decide one is going to have 1 year and then something else which is similar has 20 years. That's also not acceptable. And of course, above all, it must be just. And I think if you have all of this in mind and you test RUU 355, I believe that there are problems with RUU 355. Even if you say it's constitutional, there are these other problems which you have said can be discussed. I personally think it must be looked at again, because legislators have to legislate according to the law and according to the rule of law and according to the federal constitution. So it requires thought before this is hurried through. Now, our federal constitution embodies the rule of law, which is why the rule of law is so critical. We must make sure that all the laws that we make are clear, fair, and just. And the problem with RUU 355 is we do not know exactly which offenses are relevant in which state, in each state. That's one of the problems. Now, parliamentarians have taken an oath of office to preserve, protect, and defend the federal constitution. Article 4 says the federal constitution is the supreme law of the land. No doubt there were offenses, there were laws, etc., prior to the federal constitution, possibly hudud-like, etc., which were there, I agree. But once the federal constitution came into force, that prevails. Whether you like it or not, that prevails, because that's what Article 4 says. And you have to operate within the confines of the federal constitution. Now, it also says, Article 75, in fact, says that any law that is inconsistent with federal law, any state law that is inconsistent with federal law is void to the extent of the inconsistency. Now, it was stated that as long as it's in the penal code, it cannot be in the state enactment. That's not the test. The test is it has to fall within the state list. It's not just what is in the penal code. It is what is in the federal list that cannot be covered by the state. So you may or may not have a law on a particular, they have some intoxicating liquor and all that. You may not have a law right now. But that is still within the purview of Parliament, not the state. Now, each of the members of Parliament represents all Malaysians. Not just one community, not just two communities, all Malaysians. They must debate this legislation as they debate every single legislation. Non-Malay parliamentarians cannot be told that they cannot debate this, because then they would be remiss in not doing it. That means they're failing in their duty to their constituents. And it is, I've heard it said that Muslim MPs perhaps should support this no matter what. So these are the things I think we need to be careful of, because we need to be aware of the duties, the onerous duties of our MPs, and they must execute it, because that is their oath of office. They swore to do that. They can't do anything else. Now, it was stated that this does not affect non-Muslims, and then of course specific offenses were mentioned. I agree. In those cases you may not find non-Muslims being charged, as it were. But being charged is different from being affected. Now, Article 121A, and if you look at the conversion cases that have taken place, the thought process, and actually people say it in good faith. I'm not questioning the good faith here. In good faith, they believe it will not impinge. But when it plays out, it does impinge. For example, the conversion cases. And that went unsolved for so many, many, many years. And I'm hoping that the bill, I believe there's first reading has gone through. I'm delighted to see that. But it took so many years before that was corrected. So you cannot say it does not affect non-Muslims. I'm not sure whether you're also suggesting that non-Muslims have no right to talk about this bill, because it's a bit late. I'm here on my feet doing it. Now, don't also forget, okay, let me not talk about religion. Let me talk about the ISA. The promises that it will not be abused. What happens? It happens. So the best way to protect everyone is to state it in the legislation. If you state it clearly in the legislation, every bit of it, then you assuage the fears of everyone. If you say this is not hudud, then exclude those offences in this bill. That's my suggestion. And my suggestion is that you should also have a schedule of offences and deal with it that way. So what I will say is this. This bill, as it stands, cannot move forward. And I would say cannot be passed in the present form. I believe it is unconstitutional, and therefore I would oppose the motion. But I want to end with this, just this one little thing, if I may. 30 seconds. All right. You want me to stop? All right. I'll do that later. Thank you very much.